Good morning, everybody. Thank you all for joining us. Got a couple more folks making it in from the waiting room, and then we will go ahead and get started. And there we are. All right. Well, thank you all again for joining us today. We're happy to have you here. I'm going to get us started as I usually do with our Zoom housekeeping tips, starting with a request that you all stay muted for the Zoom today. It just cuts down on background noise and distraction. If you would like to unmute yourself at some point to ask a question verbally, that's perfectly fine. But otherwise, please do stay muted. And in case anybody else is not living in 2025, where Zoom has been part of our lives for 5 years now, your Zoom toolbar is at the bottom probably of your device screen. That's where you'll find your audio and video buttons. That's how you mute and unmute yourself or turn your video on or off. Whatever you are comfortable with as far as video on or off is perfectly fine. You might also see the chat button flashing on your device screen, depending on what kind of device that you're using, because I put a message into the chat pointing you towards our YouTube channel for videos of all of our past Q&As up to a certain point. We do delete Q&As once they get old or dated as far as statutory changes. And the instructions that I put in the chat also tell you how to submit questions during the week for next week's Q&A. But speaking of next week's Q&A, we are not doing one next week because it is a holiday week. So please don't show up here next Wednesday, the day before Thanksgiving, as we will not be here doing a Q&A. We will send out a reminder email on Sunday or early Monday, letting folks know via email that we won't be here next week. However, if you think of questions next week, you should totally feel free to send them to the info@condolaw.net email address. Even if we're off, we will keep our list running for the following week. As we tell you every week, I also want to remind everybody that we are here to talk about general information that is legal in nature, of course, but we are not here to and cannot give anyone legal advice for any specific situation. So keep that in mind as we answer your questions. Sometimes questions are so specific that we have to tell Chelsea to email you and say, sorry, this is too specific, we can't answer it. Other times we'll try to modify the question so that it's a little bit more general in nature if we think the subject matter is broadly helpful, but we're not giving legal advice. And also that means that if somebody sends you one of our videos and says you have to do a thing or you can't do another thing because of something that I said or Fatima said or Ken said or whatever, you can ignore them because, again, this is not legal advice. And I already covered that the chat function is for asking questions. If we don't get to the questions that you put into the chat today, please do go ahead and email them to info@condolaw.net. Chelsea does try to keep track of all of them in case we don't get to all of them. But if you want to be extra sure that we get it on our next list, please go ahead and send it in by email. Also, a reminder that we do reserve the right to reject questions for any reason, including if the question comes from an unidentified source. We have to be careful about the questions that we answer. We represent a lot of communities in Washington State, many of whom have board members and individual owners who participate in the Q&A. So there are times when we need to not answer a question based on the person that is submitting it. And it's not because there's anything wrong with the person or even necessarily with the question, but just because of information that we have about what's going on in the background. So if you submit a question from an email address that's like, ABC condo, like unidentified condo owner at gmail.com, whatever, we are not going to be answering questions like that. We've also been reminding everybody that WSCAI has a Wakaiowa resource guide available for sale, for purchase. And the proceeds of that benefit the Legislative Action Committee through CAI. If you're interested in learning more about that, the WSCAI website is wscai.org. Chelsea, could you put that into the chat just to make it easy for people to find? You can check out the website for WSCAI. If you're not a member, you might consider becoming a member. We find our membership to be very, very valuable and really enjoy all the educational opportunities that they provide. And then you can also ask them about the Wakaiowa resource guide. Last reminder, there are changes to Wakaiowa itself that took place, or took effect, I should say, July of this year for existing Wakaiowa communities. And there are some changes for everybody that are going to take effect on January 1st of 2026. Those generally relate to meetings. The meetings provisions of our statutes or of Kiowa is now going to be applicable to everybody. And there are also delinquency changes that will take effect January 1 of 2026. And specifically, there are new limits on the amount of late fees and admin fees until after certain specific delinquency notices have been sent. And we anticipate that we'll start getting a lot of, for example, referrals to our office for collecting unpaid assessments, where we have to go back to our clients and say, this isn't ready for us to step in yet because you can't do anything unless you've sent a notice that complies with the statute. We've been talking about this a lot. Last week's Q&A, Ken and Lisa spoke about this a fair bit. And I don't know, at least a half a dozen times in the last 2 months, we've talked, and I think pretty specific detail about what those notices are and what the limitations are on taking collection action until you send the proper notice. But if this is something where you're like, what the heck is she talking about? This is news to me. Go to the chat, click on the link to our YouTube channel, and look at the last, say, half a dozen videos to learn more about those changes that are starting January 1 of 2026. I think that covers all of our housekeeping stuff. So I'm going to go ahead and jump into our first question, which is, would fixing mold in a condo attic be considered a repair so far as reserve funds or operating fund usage? So the short answer is, first of all, I want to say that this is not legal advice. So we don't know anything about your particular structure, what your governing documents say about whether the attic is a common element, part of the unit, who's responsible for maintenance, who's responsible for cost. So this is not legal advice. This is not an answer that is specific enough for any community to determine how to handle repair charges like this. And as you might suspect, one of the things that we're going to tell you to do is look at your governing documents to see if there are specific provisions pertaining to both how reserve funds need to be used, but also whether the attic, like I said, is a common element, part of the unit, who's responsible for maintenance and repair within the unit, and the cost of that. Those things are generally called out in the declaration. And so if we had a client come to us and say, how do we pay for this cost? We have a list of sections within the declaration that we look at to determine who's responsible for the maintenance of a particular element, whether that element is part of the unit, a limited common element, or a common element, and then who has to pay for that. Because sometimes responsibility for repair and responsibility for cost are two different answers. Sometimes the person that is responsible for maintenance and repair of a component might be the association, but the owner to whom that common element or limited common element, I should say, is assigned might be responsible for the cost. The statute would most likely support using reserve funds to remediate mold in a common element attic, as long as it would most likely be considered a reserve component. And if it's a common element, it's likely that it would be considered a reserve component. The statutes that you're going to want to look at in terms of what is supposed to be included in a reserve study and how to determine whether something is a reserve component are RCW 64, 90, 545, and 550. 545 was made applicable to all communities in Washington state in 2019, which was 1 year after Kiowa was enacted. And because it references a lot of the details in 550, it kind of sweeps in the standards from 550 as well. But the short answer is that if your community is looking for whether to pay for a repair to a common element attic from the operating fund versus the reserve fund, I think either might be fine depending on the circumstances. And if you needed to quote unquote borrow money from the reserve fund out of your normal cycle, that's something you can talk with your attorney about as well in terms of what the procedure looks like for doing that. So the other thing that I want to remind everybody about is that reserve funds, reserve studies are not maintenance plans. So if your reserve study says that your attic replacement cost is supposed to happen in 2028, but then something happens to mean that you have to do that repair in 2025 or 2026, you're not violating your reserve study by doing it early. The reserve study is an estimate for what things are going to need in terms of repair and replacement and when. And that estimate then allows you to save money with the idea that you're trying to avoid having to specially assess your owners every time you have to mitigate mold or repair damage to a common element. Needing to pay for things out of the schedule that is anticipated by the reserve study is not a violation of the reserve study. It's not problematic in any way, as long as it is for the maintenance and repair of a reserve component. So I think that covers the question. If you have clarification that you want to ask for, you can pop that into the chat. And Tima, did you have anything you wanted to add to that one?
Nope, I believe that covers it.
Okay.
The second question is, could you please explain what RCW 6438-120 means, and more specifically, how it works if the bylaws allow one vote per lot? So the short answer to this question is, in this case, your bylaws mirror the statute. There's no conflict here. The statute says if a lot is owned by more than one person, each lot owner of the lot may vote or register to the casting of votes by the other lot owners of the lot through a duly executed proxy. So in this case, there is no conflict. That being said, a couple of nuances here that are worth mentioning. Your community your governing documents might say something different for a different community. And the statute really is there to address the fact that if there are multiple owners allocated to a unit, or that only one vote is allowed per unit, per lot. So for example, if you might have a situation where you have a married couple and they don't agree on their particular vote, that vote either they need to come to an agreement, or that vote is simply a non-vote, because our clients' associations are not there to navigate marital discord. So, I mean, that would be one specific that does actually come up. The subsection also says that every partial owner can vote or object to that vote through a proxy. And like I said, the governing documents might have more specific guidance as to how you might deal with multiple owners of a single lot who disagree. But if it's silent, that's our position, is that, there has to be agreement on the vote. If there's disagreement between a married couple or two owners of one unit, one lot, it's a non-vote. I think that covers it. Val, did you want to add anything else?
Yeah, I just want to clarify that we don't necessarily think that the non-vote outcome is the default when the documents are silent, but when we draft restated bylaws for our clients, that is how we resolve this type of dispute in the documents that we draft for our clients. But I think otherwise you covered it, so we'll go ahead and move on to the next question. Since Wakaiowa requires secret election ballots and also allows directed proxies, what is the best practice for handling directed proxies? Are they not technically a ballot, so they don't need to be kept secret? If they do need to be kept secret because they name the candidate being voted for, what's the best way to do that? I think the short answer is that the best practice here is to treat all votes, whether they are cast by proxy or by ballot, the same way. In other words, as a secret election ballot. I would like to note and emphasize that this provision of Wakaiowa only applies to Wakaiowa communities for now and will not apply to everybody else until 2028. This is not one of the provisions of Wakaiowa that is taking effect for non-Wakaiowa communities sooner than that. And it only applies to votes to elect and remove board members and to amendments to the governing documents. If a directed proxy directs how an owner is going to vote on those matters, then we would treat that directed proxy, as a protected record, like a secret ballot. And we would typically recommend that how the association handles secret balloting is a committee or a manager, appointing a committee or a manager to collect and tabulate the votes that may not be viewed by the candidates until after the tallies have been recorded and made official or finalized. If you would like to look more at the sections of the statute that we're talking about, this is RCW 6490-455, subsection 3A. And it says votes allocated to a unit may be cast pursuant to a directed or undirected proxy duly executed by a unit owner in the same manner provided for in the nonprofit statute. But this relates only to the method of presenting a proxy to the association. And we also just want to remind everybody proxies can be provided by email. I just attended an annual meeting for a client last night where two different groups of owners in a community of about 130 had collected proxies totaling, I think they had a total of like 75 proxies. And they presented those to the association by emailing copies of them to the manager in advance of the meeting. That's a little bit outside the scope of the question, but just worth mentioning. Tima, did you have anything you wanted to add?
I don't think so. That answers the question.
Okay.
Number 4, is it better when setting a fine for violation to be specific in the amount of the fine instead of just giving a range? For example, for a violation, there's a $100 fine with an additional $75 per month for each month the violation remains uncorrected, up to a maximum of $550 per month. That is, instead of saying the fine is up to $550 per month. Is there no difference between these two? I would say there's definitely a difference. The short answer is it is always best practice to have a fine policy that specifies the exact fine amount for each violation. We do not recommend giving owners a range. And when we draft our fine policies, they are very specific. The reason being, logically, as attorneys, when we see language, a sliding scale language, for example, we find it confusing to understand. And if we think it's confusing, your owners will find it's confusing, and that makes things difficult to enforce. Furthermore, we look at when we look at policies, when we draft policies, we try to we look at what was the intent in creating what is the intent here, and the legislator in requiring fine schedules to be distributed to owners in advance is to reduce the randomness of fines or the perceived randomness of fines by owners and to reduce the amount of discretion the board has. So the more clear these policies are in writing, the more clear they are to enforce, and there's transparency on both sides. This applies to any policy that is in force, but specifically here with fines. Furthermore, every fine requires, and most of you that I've worked with know about the due process requirements that come into play when we are trying to add fines to a ledger. Every fine requires opportunity for the owner tenant to be heard by the board before the fine is assessed. And the board always has discretion to reduce or waive fines from the schedule. So again, when we're transparent and clear on both sides, it makes due process. It gives the owners due process, and it gives them a very clear understanding of exactly what's expected and what the result is if they don't follow the fine policy. I hear, and I'm only adding this because you specifically wrote in $550 a month, and just to kind of add a note here, without actually seeing the documents, generally speaking, a fine has to be reasonable. Setting an initial fine of $550 is probably not reasonable. We certainly wouldn't recommend that. But I only mention that because that was part of the question here. Valerie, did you have anything else to add?
I think the one thing I would want to emphasize is that I think every community should have a fine schedule that specifies the amount of each fine. So first violation, warning, second violation, $50 fine, third violation, $100 fine, and, continuing subsequent violations, whatever, $250 per occurrence or per week or whatever it is. The reason for that is we have gone in front of judges with fine policies that had ranges or that had things like board discretion for the amount of a fine. And we have had judges throw those fines out of court because the point of having a schedule of fines required by the statute, because it is required by the statute, is to put owners on notice of the cost of violating the governing documents. You might know and sort of have perceived from some of the recent statutory changes how much the legislature cares about making sure that owners have notice of certain things. that owners have information given to them, that associations act with transparency, right? We've been sort of beating the transparency drum a lot lately, given the upcoming open board meeting requirements that are going to now apply to everybody. So I think your fine policy should be as specific as possible. And by specific, we don't mean that you have a list of every possible violation of the rules and then, a list of fines that pertain to each of those violations. It can be very general in terms of this is the fine policy, this is the fine schedule, excuse me, that applies to any violation of the governing documents. So you're not trying to think of every possible violation, include that in your fine schedule. You just want the schedule to specify the actual amount of the fines so that your owners have proper notice, and that if you give due process in the notice of the violation and fine, your fines will then be enforceable. So the more vague your policy is, the less enforceable your fines will be. All right, next question. In a condominium governed by RCW 6434, and that's the Condominium Act, my understanding under 6434-332 is that all special meetings require a minimum 10-day notice to owners, even though the bylaws only require a 3-day notice. Board members routinely call for a special meeting with only 3 days email notice to the owners and board members. They have scheduled 3 such special meetings in the past month. Please confirm the notice requirements in 6434-332 and provide comment on the enforceability of items approved in special board meetings with only 3 days notice. So my first comment is going to be directly to the last thing that I just said, which was the person asking us to comment on the enforceability of items approved in special board meetings with only 3 days notice. We are not going to comment or give advice in this forum about the enforceability of past decisions made by your board. We cannot do that in this forum. We are not here to give legal advice. So all of the comments that we're going to give you in response to this question are more general in nature and do not speak at all to the enforceability of the board decisions made in those meetings. The only way that you can get an answer to that part of your question is by hiring an attorney to represent you, review all the governing documents, review the board meeting minutes, review the decisions that were made, and only then can they advise you on the enforceability of those decisions. So that is not what this answer is going to be about. I also think that you might be confusing the amount of notice that's required for a special meeting of the owners and the amount of notice that's required for a special meeting of the board. Notice of any owner meeting, including a special meeting, has to be provided to the owners no less than 14 days and no more than 50 days in advance. That's for an owner meeting. And RCW 6434-332 talks about special meetings of the association. That's not about board meetings. It's about owner/association meetings. So the statute that you're citing talks about association-wide meetings that include all of the owners, not board meetings. 6490-445 is going to apply to all communities starting on January 1 of 2026. This is the Wakaiowa meetings section. So the section that you sent me about meetings is not even going to be applicable anymore in, a month and 10 days or so. And it doesn't matter what your bylaws say, unless the bylaws say to give more than 14 days notice, in which case then we would say comply with both the bylaws and your statute, right? And what the statute says now and what it will say for you in January is, notwithstanding the foregoing, notice of a meeting to address an event or condition that could not have been reasonably foreseen and for which it is impractical to provide notice as otherwise required by this statute must be given at least 7 days before the meeting. So now that we're talking about the amount of notice that's required under the new statute, it is a minimum of 14 days, but it can be shortened to 7 days if there are reasons that could not have been reasonably foreseen that require the meeting to be conducted on less than 14 days notice. And then there are specific requirements about what you have to do to try to give notice to your owners on that shortened time period anyways. So it still requires mail to everybody who hasn't opted into electronic notice, but it also requires emailing to the known addresses of all owners, even if they haven't opted in to receiving electronic notice. So again, we're not going to comment on the enforceability of boards of decisions made by your board, no matter what amount of notice they gave for their board meetings. But the statute that you cited talks about the amount of notice that is required to call a special meeting of the owners, and is not relevant to special meetings or meetings otherwise of your board. And then again, just the last reminder, and I know I probably sound like I'm beating a dead horse, which is, I need a better analogy, but anyways, RCW 6490-445, which is the meetings provision of Wakaiowa, is going to be applicable to everyone effective January 1 of 2026. And if you don't know what the heck I'm talking about or what that means, I'm going to say the same thing about this as I did about the delinquency notice changes that are coming, which is click the link in the chat to our YouTube channel and go watch some videos that we've recorded over the last 2 or 3 months where we talk a lot about these upcoming statutory changes. Tima, did you have anything you wanted to add?
Nope, I think that covers it.
Okay.
Question 6. Can a homeowners association borrow money from an individual? For example, a bank $100,000 line of credit is prime plus 1.7% interest. The current prime rate is 7%, so the rate would be 8.75. A member of the HOA board would loan the association the same money at a rate of 6% or lower. Is this legal? Also, would an HOA attorney be able to handle this kind of paperwork for this kind of loan, or would we need to go to an accounting firm? The short answer is, unless the governing documents have some specific provision prohibiting private loans or loans of any kind, there is no restriction on associations securing a private loan, as long as the board is exercising ordinary and reasonable care in doing so. Generally speaking, an association attorney would be able to draft this type of paperwork to secure a loan. However, we would recommend that the borrower and the lender each retain separate counsel to review the documents prior to signing in order to ensure there's no conflict of interest and for transparency's sake. If the lender is also a board member, we would provide the same recommendations. Specifically, we have worked with associations in the past where individual owners provided loans to the association. We've helped draft the paperwork, and it's been a perfectly reasonable and in fact, sometimes a much better deal for the client than going to a bank loan, for example. Sometimes we have ownerships with certain unit owners that are retired, or they have the funds to do this, and they welcome a 6% or 7% interest rate on their as opposed to leaving their money in a money market or whatever other form. So it's not super unusual. We have seen this before. If it is a Wakaiowa community, I must mention any loan must be ratified by the membership, and there is a very specific provision, 6490-405, Section 4, very specific to loans that is not in the other statutes. So you want to look at that as well. And just as far as reasonable care, except as provided in the declaration, the board of directors shall act in all instances on behalf of the association in the performance of their duties. They are required to exercise ordinary and reasonable care. So that is the standard, and that's the short answer, long answer. Val, do you want to add anything?
No, I think you covered it. Next question. I'm going to paraphrase this question because it's a long question that basically wants to know whether ChatGPT or some other AI resource could be used to help communities restate their governing documents, could be used by HOA attorneys in drafting restatements, and whether this could save condo attorneys and or HOAs a lot of time and or money. And I think the answer to this question is not yet, anyways. The question specifically asks if we use ChatGPT or AI in our drafting work. The answer to that question is that no, we do not. And part of the reason is that ChatGPT and AI tools still routinely get things wrong. Like flat out wrong. There have been attorneys around the country who have been censured by their bar associations For example, for asking ChatGPT or some other AI tool to draft a motion for them, ChatGPT will draft what looks like an excellent motion, and they will put in citations to case law, and that case law doesn't exist. Also, I don't know if you guys are familiar with, the when you Google something, just on your internet browser, there's that little AI summary at the top that will be like a summary of what the later like linked results are in answer to your question. I can't tell you the number of times in the last year or two that AI summary has been flat out wrong. It has mischaracterized and gotten, and not just like, oh, that's nuanced and maybe it's slightly incomplete, like flat out wrong. So until the accuracy of AI improves significantly, I don't see how it is going to be a time-saving tool or a money-saving tool for anyone. And on top of that, I will tell you that Ken, periodically over the last several years, as AI has become more common, will bring up the question of whether, like, is there a way for us to use ChatGPT or another AI tool to optimize the way that we draft restatements, reduce the amount of time required, et cetera. And earlier this year, one of our very, very skilled drafting paralegals, who's also really good at technical stuff. So basically, the person in our office who would be the best equipped to make AI work for us if it was going to, put some documents in to try to get help drafting a restatement. And the resulting documents were, number one, they were more gibberish than helpful. They were also like wildly long, and in some cases sort of regurgitated the statutes, but did it multiple times in ways that was confusing. So we've tried this and have not found AI to be a helpful tool to reduce time or streamline the process at all. And what we've found the best cost-saving approach to be is to adopt model language. So we have model documents that we've created in our firm based on the statute for certain things that are always controlled by the statute. So things like voting, meetings, notices, collections, termination of a condominium, mergers, amendments, things like that. And then we focus our attention on the language specific to a particular community around things that are not necessarily dictated by or don't have language that we can draw directly from the statute. So things like how a particular community wants to handle rentals, things like business use, Airbnbs, smoking, animals, barbecues on the decks, like you name it. So there are certain things that we have internally created really, really excellent model language for, because we're using the language from the statute, because the statute trumps anything you would put in your documents anyways. And then we focus our time and attention on language that is not dictated by the statute and that is more individual to each community. Um, I think that covers the question. And the TLDR basically, or the summary, if you don't want to, if you tuned me out and you're like, what did she say about AI? The TLDR is that it's not, it is not accurate enough, and it does not save time, and it likely will not save money. And I, sort of related to this, I will offer some commentary about communities trying to draft their own restatements. We periodically will have a client come to us and ask us whether they can draft a restatement and just pay us to review and revise it as needed. And what I tell people when they ask us this question is that, yes, we will absolutely do that if that is what your board wants to do. But our flat fees are almost every single time are going to be more cost effective than paying us hourly to review and correct a document written by a layperson who does not do this all the time. And very, very occasionally, we will still have a client that wants to go that route. And I have yet to see one that is more cost effective going that route than just picking one of our flat fees for a restatement. We think our process has allowed us to offer restatements at extremely reasonable price points. I think, as compared to industry-wide costs for doing restatements. And it allows individual clients to address the specific needs of their particular community. In other words, we're not just giving every community the same boilerplate, because that's also ineffective and does not work for every community. So I think that answers the question. And Tima, if you have any commentary to add, feel free.
No, I don't. I think that covers it.
Great.
Question number 8 is a two-part question. The first part is a proxy form required for members to participate in the vote on a special assessment? And the second question is, well, actually, I'll answer the first question and then address the second. The short answer to the first question is that no, unless the governing documents indicate otherwise, the general proxies are not required. However, the general is that owners may always vote by proxy for any purpose. So, like I said, while it's not required, it's certainly an option that most communities exercise that option. And specifically, the statute says, unless the declaration or bylaws otherwise provide, unit owners or their proxy holders may vote by voice vote, show of hands, standing, written ballot, or any other method authorized at the meeting. The second question is, additionally, if we have 42 owners present at the time the meeting is called to order, but additional members arrive afterward and are present when the motion is made to reject the special assessment, should the vote count include all members present at the time of the vote, or is the quorum based solely on the number of owners present when the meeting was called to order? So, you know, the short answer to the question is the process of ratifying a special assessment budget is the same as ratifying a regular budget. So whether it's a special assessment or regular budget, ratification may take place whether or not a quorum is present. And while the statute does not specify, we would argue that a quorum is based on the number of members present at the meeting when the vote is taken, whether or not they were present for the entire meeting. And we would count the number of votes at the time the motion is made and voted on. Late arrivals before the motion would get a vote. Late arrivals after the motion would not get a vote. This would be our position. There could be, and actually we discussed this with Ken. He was saying that there's the possibility of a motion for reconsideration if the community is following Robert's rules, to get into more detail here. But we would really want the vote to accurately reflect the desires of the membership. So we would reject most efforts to restrict voting in general. But if you're looking for, what our position would be on when the vote would be taken and how it would be counted, that's how we would do it. Specifically, the statute RCW 90-525-1 states, unless at that meeting the owners, this is about the ratification process. And as I said earlier, the quorum is not required here. Unless at that meeting the unit owners of units to which a majority of votes in the association are allocated, or any larger percentage specified in the declaration, reject the budget and the assessments against the units are ratified, whether or not a quorum is present. So just to clarify, owners are either accepting or rejecting the budget. That's what we're talking about here. I don't think I missed anything. Valerie, did I miss anything here?
No, I don't think so. I think you covered it. And I just put the text of that last statutory citation in the chat in case it's helpful for people to see that. Our next question is, what, if anything, can a community association do to regulate smoke from one neighbor that impacts another? And I'd like to acknowledge that this question came to us in a much more specific, detailed form, and the question as presented was way too specific for us. But it's been a while since we talked about smoking more generally, and so this is what we decided to answer today. The short answer to the question is that without an amendment to the declaration, you can't prevent people from smoking within their units, and likely cannot guarantee that unit owners will contain smoke within their unit, but you can try to regulate it through the rules. Generally, owners are prohibited from engaging in offensive activities, which could include smoking, depending on the circumstances. However, there is case law in Washington state that specifically found that smoke in a private residential property is not a nuisance under Washington state common law. And in that case, those were side-by-side townhomes, and one neighbor smoked on his rear deck. So the court didn't rule on whether smoking might be a nuisance under like the CC&Rs of a stacked condominium unit situation. So I just want to sort of give the caveat that case law was relatively specific It is certainly possible that there might be a different outcome if a stacked condo building sued for the same reason or someone within one sued for the same reason. But right now, the case law that we have that is even remotely applicable here is that smoking in a private home is not considered a nuisance under Washington state law. So then that comes to the question of enforcement, right? To enforce the governing documents, the board has to conduct a reasonable inquiry and they can find the offending owner in violation of the declaration. They can assess fines after they give the offending owner notice and an opportunity to be heard. But we always caution boards to be careful when taking enforcement action on behalf of or for the benefit of a single unit owner. And despite complaints from the one unit owner, the board can determine that no violation has taken place or that it is not in the association's best interest to enforce. And I will also note that the flip side of that is owners individually have the right independently to enforce the declaration against their neighbors in court. So if an association decides for whatever reason that it's not in the best interest of the association that the board take enforcement action, that may not be the end of it. An individual unit owner could always sue for enforcement under the declaration. It's possible that smoking in your unit or on your deck might be a nuisance under the declaration, but I do think it requires more than just the ability to smell the smoke. And there are a lot of factors that might influence whether a board determines if it's a violation or if it's going to take enforcement action. Other things a board could do include sending a letter to all unit owners in the association, reminding them of smoking rules, offering suggestions to contain the smoke to their unit. As a practical matter, things that we can suggest, like specifically to contain smoke, are that the people who are annoyed by their neighbor's smoke shouldn't turn on their fans because that might make it worse inside your unit. But the person who is smoking should be encouraged to turn on their fan because that will exhaust the smoke out of the building. But again, boards can really only encourage owners to take these steps to prevent smoke spread. I think the problem would have to be really significant for us to take a position that an association had to take enforcement action. And it's generally not recommended that boards take on the responsibility of installing preventative measures within the units because within the unit is an owner responsibility. If the association takes it on in one unit, then do they have to do it on all the units? Who then is responsible for the maintenance and repair of those preventative measures that are installed? Another practical suggestion is that sometimes you can find holes between the units, and that sounds crazy, like I'm talking about big holes in the walls, but I mean like cracks around electrical outlets or floorboards that can be sealed to reduce infiltration of smoke. But again, as you might imagine from listening to all this commentary, it's not a simple thing. If you have a smoking amendment in your declaration that allows you to prohibit smoking entirely, or that gives the association specific enforcement authority when smoking does create a nuisance for the neighbors, our answer to this question might be different. But otherwise, I think there's just a lot of things for the board to consider and it's not always straightforward. And I also would like to add a comment, which is Washington state law would treat this answer exactly the same, regardless of whether the person is smoking tobacco or marijuana, because marijuana is legal here. So I think that answers the question. Tima, if you have any comments, feel free to add them.
Nope. Moving on to question number 10. We have redacted this question just because it was very specific. So we are answering it as Valerie said in her opening comments. Sometimes we get questions that are very specific, and sometimes we have to completely eliminate them. In this case, we've decided to take on the question, but we've revised it to language that we can answer more clearly in this particular format. The question that we have presented here is, if and when is recording allowed during board meetings, including executive session? So the answer to the question, the first answer is that nothing prohibits recording any annual meeting or any board meeting, whether it's secret or otherwise. There is no expectation of privacy in those circumstances. The caveat here is that if you are in executive session, that is an exception. Executive sessions carry the expectation of privacy. So we would certainly recommend against recording executive sessions. There should not be any motions adopted in these sessions anyway. Furthermore, even if you have recordings of meetings, the official record of what occurred during the meeting is the meeting minutes that are approved by the board at the next meeting. So the recording doesn't in and of itself carry any intrinsic value or record, quote unquote, under the statute. So again, this is our way of answering the question as you've asked it. If you have something more specific, you'd need to kind of reach out to your association attorney if there's something more specific you need an answer to there. Val, did you want to add to that?
Nope, I think you covered it. Our next question says, I know owners are entitled to request a directory, but I thought I read somewhere that the directory with names and addresses is supposed to be distributed annually to all owners. Is this true or false? The short answer is that this is false unless your governing documents require it. If your documents require annual distribution of the owner list, then you should comply with that, but it's not a statutory requirement. Owners are entitled to request a list of all unit owners and their addresses, and they are entitled to receive one free copy per year. This is under the records sections for all of the community association statutes. For Wakaiowa, it happens to be 6490, 495. And it's subsection 1C, which says once a year, an owner is entitled to the names of current unit owners, addresses used by the association to communicate with them, and the number of votes allocated to each unit. I think it's important to note the statute also says owners are not entitled to more specific information about other units than the above. And in fact, an association is required to redact certain information when supplying records pursuant to an owner records request. So for example, RCW 6490 495 subsection 3J, records retained by an association must have an unlisted telephone number of any unit owner or resident redacted or otherwise removed prior to disclosure. Also, for example, if you have an owner within your community that is a participant in an address confidentiality program, if they've told you, hey, look, I'm part of this address confidentiality program, here's a copy of the court order, their name and address may have to be redacted from that owner list as well. So you need to be mindful of what you are required to disclose, but also what you are required not to disclose or to redact when giving that list out. I will also offer as a general aside that this year or last year, this year, I think, the record sections of our statutes were amended, and it is a little bit more ambiguous whether an association can withhold email addresses from a unit owner who asks for them. And previously, the statutes clearly allowed an association to not turn over things like unlisted phone numbers, for example. But now the statute says that email addresses are to be included on that list unless the owner has requested that the email be kept private. So if you communicate with an owner via electronic notice, unless they request that their email address be kept private, it is likely that you are required to turn it over as part of that owner roster of contact information. So one thing that we think all of our clients should be considering here is when you gather you send out your annual owner contact forms or resident information forms or whatever method you use to collect contact information for your owners and residents. There should be an option for owners to check a box, click a box if it's electronic, whatever it is, that says they want to keep their email address private, so that an association can then opt not to include that email address on a list when it's provided pursuant to an owner request. It is one more thing for boards and managers to keep track of, one more piece of information of do we disclose? Do we know we don't disclose? It is one more sort of administrative burden for communities and their managers to have to keep track of. But we do think that otherwise it would be required that you include those email addresses, especially if an owner has opted into receiving electronic notice. Tima, did you have anything you wanted to add?
Nope, I don't think so.
Okay.
So question number 12. For HOAs that allow non-owners on a board, must an owner submit their name or is there some other allowed method? Um, so the short answer to this question is that all board members are elected the same way, regardless of whether they are an owner or a tenant, or not. So if your bylaws contain specific information about the nomination process, we would most likely follow what's specifically in your governing documents. Otherwise, we rely on the statute. The statute says that RCW 6490-518 regarding the election of board members, notwithstanding any contrary provision in the declaration, prior to an election of board members, the association must provide notice to all unit owners of the number of board positions that may be filled, the qualifications of the board candidate, and the process, manner, and deadline for submitting nominations. If the board determines that any nominee is not a qualified candidate, the board shall notify the nominee, and so forth. I would add here that absent something specific in the governing documents, it is not required that an owner has to nominate a non-owner for a board position. So hopefully that answers the question. Valerie, what do you think? Is there anything to add here?
I'll add just that we have clients with longtime residents that live in their communities that are not owners. And several of them have served for a very long time on a couple of the boards of directors. So it is not uncommon for a non-owner resident to serve on the board of directors. And I agree with you that they don't have to be nominated by an owner in order to put their name in the hat, so to speak, to be elected to the board. We have a few questions in the chat and we have a few extra minutes to go through those. So I'm going to go ahead and read those out. And Chelsea, if you see that I'm missing anything from the chat, would you message me? The first one that I see here is, if an association fails to have its mandatory annual owners meeting, does this affect any board decisions or budget ratification until the meeting is held? I think the short answer to this question is no. The annual meeting is a meeting of owners where owners do things, take actions like vote on a proposed declaration amendment, elect your board of directors, and vote on other things that the owners as a whole get to vote on. Board decisions are made at board meetings, or if you're in a community that still allows this for the next 6 weeks, they can also be made via unanimous written decision outside of a board meeting. A failure to hold an annual owners meeting does not have any impact as far as I can tell. And again, we're speaking really generally here. So this is not advice about any particular decision that your board has made in this circumstance. But as a general matter, I don't see why a failure to hold an annual meeting would impact board decisions that are otherwise valid. Budget ratifications, as long as the board adopted a proposed budget, provided the required notice to the owners of the ratification meeting, and the budget wasn't rejected, then it's automatically ratified anyways. And you don't have to have an annual meeting in order to have a ratification meeting. And you very specifically don't have to have quorum at an association meeting in order to ratify a budget. So I think the short answer to your question is no. Tima, did you have anything you wanted to add to that?
Nope. I think that answers the question.
Okay. All right, next question. Can a board access residents' contact information or details from resident information sheets in order to create a tracking list for tenants, cars, etc.? I'm not really sure what you're asking here, so I'm going to start by saying please provide some clarification in the chat. If the question essentially is whether a board is entitled to access these records that are gathered by management, then my answer to that question would be that the board of directors as a whole is the group that is empowered to act on behalf of the association, and withholding records from the board as a whole seems to me to ignore the board's authority to act on behalf of the community and to govern the community. I do think my answer might be different if it was an individual board member trying to access records, and it probably would also depend on what the purpose of their desire to access the resident contact information forms would be. But I think that's all I can offer without knowing more about why you're asking the question. Tima, did you read something different into the question, or you think I'm missing anything?
I don't think so, but if there's more information in the chat, we're glad to answer it.
Okay. Next question. Are committees required to follow the open meeting requirements under Wakiowa, specifically having notice to the owners and a phone-in option? The short answer to this question is yes. If the committee in particular exercises the authority of the board, they are absolutely required to follow the meeting notice requirements, the same ones that apply to board meetings, open board meetings. The legislative intent behind these statutory changes is the idea that the legislature wants the governance of each of these communities to be happening in the full view of the ownership. They want there to be transparency with your ownership. And in particular, when a committee exercises the authority of the board, in other words, if a committee is making a decision that would otherwise be the board's to make, then those committee meetings must be open to the owners, and there must be a phone-in option. The phone-in option seems like a little bit of an odd add-on to this question, because every single one of the electronic meeting or virtual meeting softwares that I'm aware of, including Zoom, Teams, and even Google Meets, when you create the sort of the invitation link to send out to the owners, it automatically includes either a call-in number or a link to click to get a call-in number. So so that seems like an odd add-on to the question to me. And if there's a particular reason why you called that one out, please let us know. But otherwise, that is the answer to the question.
I'm the one that asked that question. Could I clarify?
Yeah, please.
Okay, so, and this, I apologize, might be a little specific. I have a board that has committees for landscape and maintenance that meet regularly and are happy to be open. They're not, obviously, they want to comply with the intent of the law.
Yeah.
They are not, none of the committee leads are board members, and they do not make decisions. They are gathering information and like strategizing on topics. And then they do make a recommendation and request the board authorize their recommendation type thing at a board meeting and present that info.
Okay.
And we're struggling just with how to comply with, again, we want to be transparent, but there's also like, this is just a lot to get to owners, and my boards are trying to wrap their brains around the amount of conversation they have. They're not making decisions, but they're trying to gather the information so they can be productive in a board meeting, if that makes sense.
Yeah, it does make sense. So that would be something I would call like an advisory only committee, and not a committee that exercises the authority of the board. My recommendation would be that those still be open to the unit owners so that they can listen in on what's happening and hear the discussion. But I know there are attorneys in our practice area who would tell you that those meetings don't have to be open, because they're not board meetings and they're not committees that are exercising the authority of the board. And I think this is an example of where reasonable minds can differ. And I guess what I would say is, in particular, because you're saying these are happening regularly, if there's a regular schedule of these, and maybe it's the same Zoom login or whatever for each of these committee meetings, I don't know why you wouldn't just send out an annual schedule of those meetings ahead of time, let the owners observe. I do think that in a committee meeting like this, where no decisions are being made, you don't have the two board members part of the committee requirement met, and they're simply making a recommendation to the board on certain issues. This is very clearly not a board meeting, and I don't think you would have to provide for an owner comment period in the beginning. And I don't know if that's part of the confusion here either.
Honestly, for this particular one, the issue is sometimes these meetings are an hour and a half, 2 hours long, and we as the management company have Zoom and set up meetings, but we don't attend these meetings. And so then how, like the logistics of providing a Zoom link that everyone can access if they have more than, an hour and a half and that kind of thing. So it's more of that.
Sure.
So I think you've helped me a lot, but thank you very much.
You are very welcome. That does take us to 30 minutes. That takes us to 11 o'clock. So I think we are out of time for answering any additional questions from the chat. If we missed your question, feel free to email it to info@condo.net. We will also try to, keep track of these from the chat ourselves. And we thank you for joining us. A reminder, we will not be here next week, so please don't show up next week, but we'll see you in 2 weeks back here.
Happy
Thanks,
Thanksgiving.
everybody. Bye.